joining us on the conference committee regarding SB 40, and we're discussing Kansas Emergency Management Act. So kind of picking up where we left off last night, we had some good, robust discussion about kind of the differences between the Senate and the House bill and where we could best come together to, again, create a balance between government response to emergencies and individual rights and liberties and some common sense. So with that in mind, we had talked about and gone through there's a comparison chart between the two bills that I believe is available online that compares literally side by side the two bills for everyone to take a look. And we talked some about specifics yesterday. And so last night, after our conversation here in committee, I went back and looked at some things, some differences between the Senate and the House bill and how they were structured and how we could bring them together. There's some pieces of the Senate bill that we talked about that would need to be changed a little bit and bring some pieces from the House bill together too. So with that, I have an offer to make from the Senate, the Senate's position, kind of doing that, hopefully bringing together the best of both, some of those areas that we talked about. And I would hope we all find that it's a good balance between, again, that government response, an appropriate government response, and protecting individual rights and liberties. So with that, I will ask our reviser, Mr. Thompson, to please go through the draft with us. You'll see that as we go through it, it's pretty easy to see where the changes have been made because they are literally in what's called, for lack of a better description, balloons. So you can see where the differences are in what the Senate bill has and what it strikes out and what it would add and include from the House. So with that, Mr. Thompson?
Madam Chair, before we go to the reviser, could we have that document distributed to the committee members who are online, please?
Sure. And I believe Mr. Thompson is able to put it up on WebEx for those and online for those who are at home to follow along. I don't know if my committee assistant is listening or participating to get that to you, but just a moment, Representative, and I will send it to you.
Madam Chair. This is Jason Thompson with the Reviser's Office. I just sent the email. That's what I was working on. So all 6 of you, plus both committee secretaries and staff, should be receiving that, and then hopefully it'll be forwarded further than that. So I have
it now. Thank you, Mr. Thompson. I appreciate your help.
Yes, thank you, Mr. Thompson. Then if you'll proceed with the explanation.
You bet. Thank you, Madam Chair. Again, Jason Thompson with the Reviser of Statutes. You have hopefully now in front of you or on your screen here the balloon amendment. Trying to get my notes pulled up so I can walk through this with you. So 2 things I'll note at the top that are new to the draft, both noted here in the title. An amendment to KSA 48-932, which is part of KEMA, to specify that local disasters may be declared for a public health disaster. The current statute only references a disaster, and the Senate divided the term into disaster and public health disaster. So this is in some ways a technical amendment that's necessary, but it also allows the Senate version to name the disease and require that the declaration of a public health disaster name the disease. And that amendment assists in some other restrictions that are provided in the Senate bill so that that disease is named in even a local public health disaster emergency. The second is an amendment to KSA 75-3711. This one is a technical amendment, we would say. There's a reference to KSA 48-924 in the State Finance Council statute. And because the Senate version removes the Finance Council from this procedure, that reference needs to be removed. I note that is in the House bill. HB 2416 has this same provision in it because we caught it during that committee work, but we did not catch it in time to make the amendment in the Senate bill. So 2 new things to the draft that I wanted to just mention right off the top because they're right there on the first page. Then I'll move to section 1, and I'll go down a couple pages on the screen here to the changes on page 4. So here in section 1, we're clarifying that you call and hold the meeting essentially. So the joint committee shall call a meeting, the chairperson shall call a meeting, and it will be to occur not less than 24 hours and not more than 48 hours after receipt of the proposed executive order. And then the meeting may occur less than 24 hours after receipt of the order if the Attorney General provides their opinion on the order in less than 24 hours. So we have a window of 24 to 48 hours and a shortened window if the process goes faster than that. But it all basically allows the Attorney General the time that they need to do the opinion, and then the Joint Committee is required to meet. Then you'll see some factors listed here in the big box on page 4. Those are the guidelines from the House bill that the LCC would be looking at in considering whether to approve in the House bill, whether to extend powers or whether to extend an order. In the Senate bill, it's when making a determination about approving a proposed executive order. All of these issues would be considered. And again, these are drawn from the House bill. Finally, we add a provision on the next page, page 5, that is new to the draft. And I would note that it just says, notwithstanding any other law, if you're in a state of public health disaster emergency, the Secretary of Health and Environment and the Adjutant General are only allowed to adopt temporary rules and regs. They are not allowed to adopt any permanent rules and regs under our Rules and Regs Filing Act. And for purposes of this section, those temporary rules and regs to be adopted are deemed necessary for the preservation of public peace, health, safety, or welfare. That's in conformity with the Rules and Regulations Filing Act for what temporary regulations have to be. So we're deeming them temporary rules and regs, even though they probably would qualify that way anyway. And they can be extended for one additional 120-day period. So temporary rules and regs only, they can be extended. And then permanent rules and regs can occur after the public health disaster emergency, but not during. Section 2 then, we make a technical change. You'll see here on page 7 in line 21, there is a majority vote of the members that's mentioned in the Joint Committee statute, but I note there is a unanimous vote required in one other part of the bill. And that's actually preserved in current law. A unanimous vote of the Finance Council is required for a certain extension, and that's preserved for the Joint Committee. So we had to note unless a unanimous vote is required by statute in a particular case. So this is a technical conforming amendment that I would suggest is needed to be consistent. Then this section 3, I'll skip for now and we'll come back to because it's the city health officers, and it's going to make more sense if we talk about the city health officers in context with the other health officers, sort of like we did in the comparison chart separately, sort of at the end. It's kind of a big issue. So I'm going to skip by page 7 and 8 and go to page 9, new section 4. This is the action by the aggrieved party in the district court. I'll note first that it limits the aggrieved party to bringing their complaint in the district court where the order caused harm, not where the party resides. That is the strike here in line 10, 14, and 26. Those 3 strikes remove the ability to bring the action where you reside. The aggrieved party instead has to bring it in the district court at the county where either the city was located, the order was issued, or the school or college was located, depending on the circumstance, but not where you reside anymore. The other change here in section 4 is that we add a provision down here at the bottom of page 9 that allows the Supreme Court to issue emergency rules of procedure to facilitate efficient adjudication of proceedings. That can include consolidation, other expedited processes, essentially a provision that we picked up from 65-129C, the 72-hour hearing provision. There are some things allowed under their emergency rules of procedure that this would allow the court to do in order to expedite all of these cases that they might receive and deal with those efficiently. And then finally, on the next page, page 10, the Senate offer here clarifies that any relief under this section, so any relief granted by the district court, shall not include any stay or injunction concerning the contested action order or policy that applies beyond the county in which the action was taken, the order was issued, or the policy was adopted. So there couldn't be, for example, a Shawnee County judge could not enjoin, anything beyond Shawnee County. And so this would effectively keep everything local, is the goal of that provision, I think. The next group of amendments I'll kind of go through together here is a similar provision that's added in section 3, 5, 6, and 18. So I will just mention that it's in all of these places. A similar provision to what I just talked about for the courts that allows each of those governing boards or bodies to adopt emergency rules and procedures in order to facilitate their action. They could potentially have a number of hearings, a number of decisions, and they may need some emergency rules and procedures to sort of deal with all of those at the same time, including consolidation, for example. I also note that those sections, we amend the definition of accepted scientific. Let me see if I can get to one of those real quick. So at the top of page 12 is a good example. So this definition appears in 3 or 4 places in the bill, but here is just one example of what would be stricken. We strike the word includes on page 12 in line 3 and add may include, so that the definition says high quality scientific data that may include systematic reviews of completed high quality randomized control trials. So it would not be required that those exist, as was discussed yesterday briefly. That may not exist for these new diseases. And so it may include those, but it's not required to include those. Let me see what's next here. There's also a change, go back to page 10 very quickly, in section 5, 6, and 17, the same change that appears on the middle of page 10, the addition of wherever we find section 1, the addition of a declared state of local disaster emergency related to a public health disaster under 48.932. You'll recall I added that section to this amendment, and now we can reference it as being comparable to a section 1 disaster under appropriate circumstances. So that change appears in sections 5, 6, and 17 for that purpose. The only other thing on page 10 that it looks like I didn't cover before is this new subsection A3 that is inserted in line 33. So in the event of a public health disaster under section 1 or a local related to public health under 48.932, only the governing authority of each non-public school shall have the authority to take any action, issue any order, or adopt any policy that affects the operation of any school or attendance center of such governing authority. So this is the private schools provision that says they have explicit authority over their schools and attendance centers and have exclusive authority over them during a declared public health emergency under either 1 or 48.932. So that provision is there on page 10 in line 33. We already addressed page 11 and page 12 and page 13. So let's move to page 14.
Just a moment, Mr. Thompson, if you could hold just a moment. It's a lengthy document for sure, and the balloons are very clear about what's being changed, and the strike-throughs are clear what's being changed in the Senate bill as well. Just wanted to take a moment to stop and see if we had any questions. We're kind of at about the halfway point through the bill. If we had any questions from anyone on the committee for the revisor about what we've discussed so far.
Madam Chair.
Yeah, go ahead, Representative.
I wanted to make clear, yes, there will be many questions with a lot of information being changed here, but at this moment, I don't have them formed in my head, so probably unless the chairman has something else, probably is best to just let them continue.
Okay, perfect. Then we'll continue and then take questions at the end. So thank you, Mr. Thompson. Go ahead.
All right, thank you, Madam Chair. Jason Thompson again, continuing. So on page 14, we move to the KEMA sections. This one is 48.904, the definition section we talked about in the comparison chart where we define disaster, public health disaster, and sort of separate those two categories. There's an amendment in line 26 right here that disaster under this bill does not include a public health disaster or any economic or financial crisis. So those would not be disasters. Public health disaster is then clarified that it does not include foodborne illness or a radiological disaster. So those two changes are made there on page 14. Then on 48.923, that's on page 15. This is the statute that provides restrictions on what the governor and other executive officers cannot do under KEMA. So you'll see the lead-in language here, notwithstanding any other provision of law to the contrary. The governor shall not have the power or authority to temporarily or permanently do this list of things. And this would add in the alter or modify the criminal code or the code of criminal procedure or criminalize conduct that is not otherwise criminal. And that language does appear in the House bill. So the Senate offer here incorporates that into their 48.923 section. The other addition or deletion, I should say, in 48.923 is on page 16. The provision in subsection B6 capital D regarding restrictions on medical facilities is stricken. So that's the strike there in lines 18 through 22. So all the others remain, but there's one change to the criminal provision and one deletion of the healthcare facility provision. Moving then to 949. We can skip over several pages here in the blue and I'll just scroll past them. And as we go by on page 21, I note that is where 48.932 would go, the local disaster emergency. And so we'll talk about that briefly at the end when we get to that attachment, but that would be inserted here on page 21. So we get then to page 23 and the definitions section in 48.949, the Kansas Intrastate Emergency Mutual Aid Act. This is where we change 911 dispatch center personnel to 911 call center public safety telecommunicators. So that change is made here. And then we also clarify that these emergency responders include physicians, nurses, and we add physician assistants. And that should cover pretty much all of the medical folks that the Senate was trying to include here, or that the act was trying to include before. The next piece would be all of the health issues. So we move into 65-101. This is where the Secretary of Health and Environment has general powers and duties provided. And in the Senate version of the bill, there are several new provisions that restrict those powers. This offer moves all of those provisions, nearly all, into a new subsection that clarifies that these restrictions only apply during a public health disaster, either a state public health disaster or a local public health disaster. And they only apply with respect to the named disease. So this new subsection at the bottom of page 24 has a lead-in now in this box that the provisions of this subsection only apply during a declared state of public health disaster emergency, either under section 1 or 48.932 related to public health, with respect to the disease named in such disaster emergency declaration. So we're very narrow and restricted by this provision. And so then the secretary would be limited in the orders they could issue under subsection A5, the actions they could take, and all the requirements that are in the Senate bill would be narrowed to this situation only. And then the secretary would have their normal authority under normal times. So that's what all these changes do, is move all of that under subsection C. Each of these becomes a paragraph under that subsection. We then add a couple of paragraphs that the secretary shall not have the power or authority to mandate immunizations related to the disease described in this subsection, and that the authority to issue an order under 65-129B, which requires an individual or group of individuals to go to and remain in isolation or quarantine, is not limited by this subsection. So there's a couple of additions there as well, but again, all moved under this restricted time period only. And then I would note here on page 25 in line 31, we have that same definition of accepted scientific, but that includes change to may include. So there's another example of that. I can briefly get into 65-119 and 126. Those are on the bottom of page 25 and onto page 26. Both of these restore the local health officers, because the Senate position is going to restore local health officer power during non-public emergency times. So we're reinserting them in both of those statutes. and clarifying that the health officers cannot prohibit schools, community colleges from operating during the declared state of public health disaster emergency. So again, narrowing when this applies to make clear that they have this authority generally, but during these particular times, those powers go under the other provisions of this bill to the local entities. So that's what those changes on page 26 are doing. And at the bottom of page 26, this large box that I say restores current law in B, that would essentially put us back to the current law where they have general powers, and those orders that are issued are reviewed or amended by the board. And then a new subsection C would put everything new in the Senate bill under this declared state of disaster emergency only. So only under those circumstances would those apply. The language here is a little different, so I'll focus on it for 1 second. So during any declared state of disaster emergency under 48.924, during a public health disaster emergency under section 1, or during a local emergency under 48.932, the local health officer shall not have the authority to issue any order regarding a pathogen associated with such disaster, and that prohibition continues for 1 year after the termination of the disaster declaration. The officer may only issue recommendations during that period, as described in this paragraph in this subsection. So this restricts local health officers for the duration of the emergency and for 1 year after to only issuing recommendations. Outside of that time period, they have their current law powers to issue orders and have those reviewed by the local entity. So that's what all that does, and that's what all the changes on page 27 do. I won't get into them in detail unless you need me to, but again, putting all of them under that restricted time period only, rather than the broader application they had as the bill came to you. Moving down through the bill, I think the changes on 28 and 29 do the same thing I was just talking about: facilitate current law, restore those restrictions only to the limited time period. And then we get to the 2 sections that are inserted at the very end. So attachment A is on page 31. That's 48.932. Local disaster emergencies, just clarifying that they have the ability to issue a declaration for a disaster or a public health disaster, and clarifying that they issue a proclamation declaring it. That's not a change in law, just a clarification of what it says there in the beginning. And then the proclamation declaring or terminating down in subsection E requires that it name the disaster. And that facilitates some of the changes that we dealt with earlier. The final amendment, again, as I said, is that 753711, attachment B on page 32. Here is the strike here in subsection B2 of 48.924. So that small change and a couple other little technical cleanup matters are the only thing that are in this section. And again, that's in the House bill as well. This would be a change we recommend as a technical change in whatever bill you adopt if you move away from the Finance Council model, because this would make this Finance Council statute would need this small amendment if you go away from the Finance Council, as both bills propose to do. So with that, I think I've covered everything, and I'll see if you have any questions.
Thank you, Mr. Thompson, for the thorough review. That brings us then to questions from the committee for the reviser. And we can wait a moment to allow you to finish scanning through and see what questions you have. Yes, Representative Ralph.
Thank you, Madam Chair. I'll jump in because I've got a couple that I just noted, and I know the chairman will probably either have some or may want to adjourn for a few moments to take a look. But while it's fresh in my mind, because it was a question I had last night. Jason, I've got a question, and I'm going to initially focus on the use of the terminology accepted scientific means. I think there's some balloon related to that at the top of page 12. It's been some time since I was in the courtroom, but I know the courts have worked through consideration and presentation of scientific evidence over the last many decades, and it brings to mind the evaluation of scientific data or information that the courts have provided some guidelines and some tests for how that is done. And I'm assuming that this particular definition of accepted scientific and the references to scientific data and the like did not draw upon any of those tests that have been established through the courts for evaluating that type of evidence or testimony. Would that generally be fair?
Go ahead, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson with the Revisor's Office. Madam Chair and Representative Ralph, I recall that this definition is more tailored to the medical side and comes from that aspect rather than the legal side and the court side. So that's my recollection, is that it is not looking to be sort of an expert witness evaluation of scientific data in a court sense, but more of a medical terminology about the methods of control and intending to remediate infectious disease. High quality scientific data doesn't get into sort of more of the legal standards, so I think the short answer to your question is yes. I don't think it considers those legal standards. It's more medical purposeful.
Yes, and I appreciate that, although I am concerned that all of this language is there so that we can withstand what we anticipate would at least be 72-hour hearings in front of a court and potentially appeals. But in looking further at that particular section or session, now that we've only used the word terminology may in regard to randomized controlled trials, I'm assuming, and I haven't seen it in here, that we don't have any definition for what high quality scientific data would be, nor do we have any direction as to who that data must be acknowledged as effective by in any of the language of this particular section, do we?
Mr.
Thompson.
Thank you, Madam Chair. Jason Thompson again. And I scrolled down on the screen here to section, to page 25, where the whole definition appears in one place, so we could kind of all see it together. Again, this appears 3 or 4 times in the bill. It's the same each time, maybe with a change to the lead-in only, but the definition is the same. So accepted scientific does mean these methods of control employed and intended to remediate infectious, contagious, or communicable disease that are acknowledged as effective by high-quality scientific data that may include these systematic reviews. So this is the complete definition, nothing more. So high-quality scientific data would be up to the body or the secretary in this case, whoever is issuing their order or their decision, to acknowledge this is the data that we use, this is why we believe it's high quality, and then it would be up to the reviewing body to determine whether that was correct. And so I think it leaves that a little bit open, as you were noting.
To go back, then sticking on that same subject, as I go back to, I think, page to page 9, I'm looking at line 2. And in that section, and it may read the same as what you were just referencing, because it's another section that is talking about a definition, or as that term is used. I note in the previous new section 3 related to cities, it talks about relying upon accepted scientific means, and then at line 2 there, we actually define only accepted scientific means. And I'm wondering if that was intentional, that or in this particular version, there was not an effort to define accepted scientific means, or whether there was just a word that was unintentionally left out there that accepted scientific means, and go on with the definition. Can you shed some light there?
Mr. Thompson, and I think the confusion might be means as used on line 2 of page 9 is a verb, not a noun. But go ahead, Mr. Thompson.
Thank you, Madam Chair. This is Jason Thompson again. And yes, there are a couple things going on here. Both that in this case on page 9, it's the term accepted scientific has this meaning, as the chairperson was stating. And as Representative Ralph noted, that term that accepted scientific is attached to is accepted scientific means in one place, but it's accepted scientific something else in a couple other places. So in order to get this concept to attach to all of those places where that accepted scientific language was with a third word. This is how we did it in those 4 places that we put this definition. And unfortunately, it was just the way the other statutes are worded that it couldn't always be accepted scientific means. I think one of them was accepted scientific justification, for example. So that term would modify justification. So part of it is a drafting choice, but part of it was also just, it was needed to be that way because it's not always the same 3 words used. It's just the first 2 words that are used each time.
I appreciate that explanation, and it's one of the reasons that it significantly concerns me that as we add additional information and provisions and such to what we have talked about as being a streamlined version of the House situation, when these pandemics or epidemics arise in the future, we will be asking people to start from a blank slate again in how we approach these. And we will create all of the same confusions that we are having right now as we look at this, rather than building upon the precedent of what we have determined to date and then making it more clear by the things that we do. And I think that's just one example of one of the concerns that I have. But I'll relinquish the microphone at this point for other questions. I do have others at the appropriate time.
Sure, thank you. And we would be looking for going forward about what we're really looking at is, due process and what process we have in place to deal with whatever might come up in the future, and not necessarily, foolproof that, we have to define it right now, but we also can't then have a situation where it's a one-size-fits-all. So, if there are other suggestions for the term accepted scientific from the House, we hadn't seen any definition. So, that's definitely something we can be listening for and looking for definition from the House as well. So, any further questions or concerns or thoughts?
With permission, Chair and the Chair, I don't mean to dominate the time, but I've got a couple of others that would just be while we're here at this point and to make use of the time. I'm looking at a reference at page 8, line 3 of your bill, and I'm working off the original bill, so I hope it matches up with the balloon that's just sent. But it's a section 2, capital A and capital B, and I was concerned last night as I read through that those 2 sections appear to be contradictory to me, and I'll tell you the concern that I've got is in section A, it appears that we are talking about, and understand, I think we need to have this limitation, but under the capital A, it appears that we are allowing a city, or we're telling them they can't issue an order that substantially burdens any religious activity unless, and then we provide a way out so that it could be done. And then in capital B, we seem to, because then there's an or, and under capital B, we seem to say prohibition, period. Those appear to be contradictory on their face, which leads me to a concern as to whether the Senate actually has a position in relation to that particular section.
Sure, thank you, Representative. And I think it's probably a drafting position. So if Mr. Thompson, if you could first address the strike through in section 2, capital A on page 8, because I think it's addressed elsewhere, and then address why the or there when, if we really intend to be prohibiting substantial burdens or inhibitions on these activities, why do we have the or clause there?
Thank you, Madam Chair. Jason Thompson again. I'm going to have to search on my other screen in the bill, but I believe that the inclusion of the word religious in Cap A is a mistake because it was later moved to Cap B. This didn't get stricken. I will confirm that that's the only place that this happened. But this is the 2-part test that the Senate discussed before. The governing body is not allowed to do anything that substantially burdens or inhibits certain things unless they have a justification. That's Cap A. And they're also not allowed to do Cap B, which is burden or inhibit religious gatherings or activities. So it's a lower bar, not substantially burdens, but burdens. And it's a complete prohibition, not a you can't unless, like capital A is. This strike here is to move it down into this box at the bottom of page 8. So again, the goal was to restore everything back to close to the way it is now, where the local officer, the city, or the city health officer can issue orders. But under these specific circumstances listed here in the box in the middle of page 8, again, under a public health disaster emergency, essentially, they're limited for a certain time period, so 1 year after that disaster ends, to certain things that are only recommendations. And the city has to be the one that issues the orders. And that moves these provisions here from general provisions into the subsection that's more restrictive. So it moves from 2A down into 6A of the new subsection. So that's why it's stricken here. But I do note it does still have the word religious in cap A. I think that's a mistake. I'm going to attempt to look at that while I finish talking here.
If you're speaking, we can't hear you. I think you'll need to speak directly into your microphone, Mr. Thompson.
Madam Chair, this is Jason Thompson. I'm still here. I was not speaking at the moment. It does appear that each time I use that substantially burdens in cap A and burdens in cap B, that religious is in A and B. And I believe that's probably just a drafting error along the way. I don't see any reason that religious should be in both. So that would be something I could fix in this corrected balloon that I just don't think we noticed before.
Okay, great. Well, I'm glad we caught that. And then actually by moving it out of section 2A on page 8 and down in the balloon in section 6, like you said, it becomes more restrictive on cities and as a governing body. And again, if we put religious in subsection B, it's not only can the governing body not burden or inhibit, can't burden or inhibit religious activity at all. So does that answer your question, Representative Ralph?
I guess it determine it based upon whether there are changes made in the language. But yes, they are contradictory, and that's what I was wondering.
Right, because it was in there twice, before the or and after the or. And then it would be something we could strike out in the subsection A, the first indication in reference to religious. Other questions from the committee? Yes, Representative Ruff.
Thank you. Thank you, Madam Chair. One more item, as I know we're getting short on time. Jason, I'm looking at the definition of public health disaster. I'm looking at page 14, line 27. It's subsection E with the definition of public health disaster. As I look through that, and it feels a little like trying to diagram a sentence back in school to try to get down to the specific of the question I'm asking, but it appears there that a public health disaster under this definition could be an imminent threat of severe injury from any infectious disease that is human to human transmissible. So am I reading that correctly, that this could actually, a public health disaster could be declared if there was only an imminent threat of a severe injury to a single person related to an infectious disease that is human to human transmissible?
Mr. Thompson, if you can reply.
Thank you, Madam Chair. Jason Thompson with the revisor. To be frank, we're copying the language from disaster. Not to cop out on this, but disaster means the occurrence or imminent threat of widespread or severe damage, injury, or loss of life resulting from a natural disaster. So the imminent threat of injury, the imminent threat of loss of life or property from one of these things is the concept we were trying to pick up. So I suppose a governor could parse that into it's the imminent threat of severe injury from a contagious disease and declare a disaster on some small number of people potentially. And then it would be subject to all the rules that you normally have. I mean, I think the point is, I suppose my point is twofold. One, we're just trying to mirror a disaster, and so I didn't dig into the weeds on this too much as the representative did. But two, it's a fair point, and so if there's a concern that a governor might issue these disaster proclamations on a smaller basis than have been done in the past, then we have this same problem in disaster and public health disaster. And you might want to consider how you want to deal with that, if at all, or whether you're going to allow the governor to use their judgment. And I guess I'll just stop there.
Thank you.
Jason, thank you. And I'm not quibbling with the use of the terminology that came down from disaster. Yes, obviously that was done and that was appropriate. I guess I just wanted to make the point that normally when we think about disasters, we do think about something that is widespread in some fashion, but actually the way this is drafted, or actually I guess we should say the way it was drafted, widespread is not required in either of these definitions, and more specifically now, I think we probably would agree that when we go to a more specific definition from disaster to public health disaster, somewhere down the road, if this is reviewed, that specificity will come under the microscope with a court, and so widespread is just not necessary to this particular definition if that were to be invoked. So again, I'm not quibbling with the drafting. I just wanted to make sure that that was clear so that we understood that widespread was not necessary nor any particular number of individuals. Thank you, Jason. Thank you, Madam Chair.
Thank you, Representative. So is your concern that a court would find widespread is not defined enough, or I don't understand what the concern is?
My concern is
Okay, so that's, okay, I understand that then. So, okay, other questions? And again, that would then be consistent with the House position that we don't separate out a public health disaster at all.
Yes, I just didn't want to speak on behalf of the chairman here, but yes, that is true.
Okay, thank you. And to address kind of that thought, as I was going back and looking through the House bill last night, I did note that the House bill does recognize that there are certain different kinds of disasters, including on page 10 of the House bill at lines 16 through 18 regarding what a Board of County Commissioners may do regarding issuing an order relating to the public health of humans that is not related to the food supply. So that to me would be a virus-induced type of pandemic. So I think we can all agree, even the examples we heard yesterday in committee, that there would be, cybersecurity disasters, there would be radiological disasters, and so we're already talking in the realm of different types of disasters, which is what the Senate bill structure gets at, that which has been, quite frankly, in law since KEMA was created, I think about 50 years ago, to separate out the different kinds of emergencies. So the Senate bill is just consistent with that and actually helping clarify and streamline what you do in each different kind of emergency so that you can have, you're not putting on a one-size-fits-all that I think has been frustrating to a lot of people and created a lot of the concerns that we've been hearing about in emails from constituents. There was a question yesterday about how the Board of Regents is different than the community colleges. And Mr. Thompson, if you could explain the difference that community colleges have a publicly elected board, and the the Board of Regents is under the executive branch, so there's a difference in how those would respond and kind of what they're covered by. If you could touch on that for a moment.
Thank you, Madam Chair. This is Jason Thompson with the reviser, and unfortunately, you've got the wrong reviser for that question. I do recall from the Senate discussion, particularly Senator Baumgartner, that what you just stated is correct. Community colleges have elected boards. I also recall the Board of Regents is a different entity entirely. I would say in the Senate bill, the way community colleges and technical colleges are treated here, and I moved to page 12 of the balloon if people wanted to look back at it. During a public health disaster emergency, either under section 1 or a local one related to public health, those entities, the technical college board or the community college board, would be the only ones that govern the operations of those colleges, just like the local school districts under section 5. And so that particular issue is here. The Board of Regents is not here, and I presume that means they would be subject to, their typical, basically the way they acted now, which I'm not familiar with enough to comment on with any competence right now. But they are not specifically included in the bill with any special provisions, unlike school districts or community colleges and technical colleges. So I guess that's probably all I have to offer.
All right, thank you. And to get back to my earlier point, question for the House, when the House bill does specifically on page 10 at lines 16 through 18, talk specifically about relating to the public health of humans that is not related to the food supply. How do you then say that we're not talking about a separate type of emergency that we need a separate type of structure for when that is already included in the House position? I would just like some comment on that.
Sure, just to clarify, that section is the provision that talks about when a county can issue a less stringent order. So it's not talking about different types of disasters. It's just saying that a county commission cannot issue a less stringent order when it has to do with the food supply. Because as we heard in committee from the Department of Agriculture, they're concerned that you may have cattle or crops that go acres and acres, across multiple counties in western Kansas, and how would they possibly comply with 4 or 5 different county orders if all the cattle were within one fence and it crossed over county lines? And so we're simply saying that a county commission could not issue a less stringent order when it came to the food supply.
And
It's still one type of disaster.
Right, again, one type of disaster. We've got different types of disaster. Your response indicated there were disasters that have to do with cattle, that have to do with crops. And I would beg to differ that on page 10 in the specific language we're talking about in the House bill, it says not related to the food supply. So that would mean related only to humans and to only the public health of humans, which is exactly what the definition of public health disaster does. So I think we're more alike in our two positions than...
I believe you're reading that incorrectly. Jason, would you like to explain to us what 13 through 18 attempts to do?
Yes, go ahead, Mr. Thompson, please.
Madam Chair, this is Jason Thompson with the reviser. If Natalie could take what the House bill does in that particular instance, I think she's...
Good pass off, Jason.
Yeah, better qualified here. I could read you exactly what it says, but I think she has the context better if she's...
Yes, please go ahead,
At least what our
Nelson.
intent was. And if we didn't get the language right, then we do need to fix that.
Sure. Thank you, Mr. Chairman. And I would point out that the House position on this actually just retains current law, except that it adds that provision exempting the food supply, and that is because we did during the interim committee hear from the Department of Agriculture related to that. So the House position there would just be to retain what the current law is. It doesn't make any changes to the type of disaster that it is. It still would just be the one type of disaster. Just that during a state of disaster emergency, the Board of County Commissioners would be able to issue orders related to public health that are less stringent.
Thank you, Ms. Nelson. Then I guess why exempt the food supply from the type of emergency if all emergencies are the same? It doesn't seem to make any sense.
We're not exempting the food supply from the disaster declaration. We're simply saying that county commissioners cannot issue less stringent orders than a statewide order that the Department of Ag would be supportive of regarding cattle, for example.
Regarding the public health of humans in particular.
No, if you read it, the Board of County Commissioners of any county may issue an order relating to the public health of humans and then leave out the rest of that. That includes provisions that are less stringent. That's current law. We're just saying they can't issue those that are related to the food supply.
Actually, for those who don't have the specific language in front of them, it is a specific change that the House bill is making to current law by including, they add the words of humans that is not related to the food supply. So that is a different and distinct exception than is in current law, because current law doesn't have the italicized language of the House bill. If I'm correct about that, Ms. Nelson, if you could confirm that.
It's actually Ms. Scott.
I'm sorry, I'm thinking of Natalie Nelson. Sorry, not Natalie Scott. Apologize, Natalie. Sorry about that.
Natalie's here as well. Madam Chair, the change made here, it's really almost an exclusion. So when it comes to a local order related to public health, then the Board of County Commissioners would be able to provide a less stringent order. And yeah, thank you, Jason, for that. And so this is just saying that they cannot issue an order. Say we're in a disaster emergency that is related to cattle. So this limitation is not just for public health disasters. This is any type of disaster that we're in. It could be a human pandemic, kind of like what we're in right now, but it could also be an agricultural type disaster. And so in those cases, the Board of County Commissioners would not be allowed to enter a less stringent order if it's about the public health related to the food supply. The testimony that the Joint Committee heard from the Department of Agriculture talked, briefly about how public health is a little bit broad, and because the food supply chain is a public health issue. They were concerned about having the different rules, as Chairman Patton indicated.
Okay, thank you. And we're clearly listening and hearing, talk about cattle versus crops and public health and food supply and things like that. And again, we've talked about cybersecurity and radiological disasters and things like that. One other last quick question. In House Bill 2016 that the legislature worked on in June 2020, the special session, was there any discussion there about public health language that at all mirrors either what's in the Senate bill definition or on page 10 of the House bill that we've been discussing? And that would be a question, I guess, for Mr. Thompson or Ms. Scott.
Madam Chair, I believe, and let me pull it up here. House Bill 2016 is where that language was actually added. So if for those of you who might have House Bill 2016 in front of you, on the enrolled version of that bill at page 34, that's when that new subsection H became law. So that portion of law didn't exist before that, before House Bill 2016 during the special session.
Okay, so then the legislature in the special session last June in response to the current emergency and the pandemic agreed as a legislature and was enacted into law regarding there's kind of a special need to address public health emergencies because that's there then in HB 2016. So further questions for the reviser about the Senate position offered other than what we've already discussed? I'll just note, I think Mr. Thompson did a nice job of indicating where provisions of the Senate bill were struck, and then incorporating also provisions from the House bill related to the Joint Committee on Emergency Management would be required to meet in a certain time frame, 24 to 48 hours after the review from the Attorney General. That was incorporated from the House position, as was the guidelines that were in place for the LCC in the House bill to make those applicable, those same guidelines applicable to the Joint Committee on Emergency Management. Good provisions, and also that private schools were specifically addressed in the House bill, and that language was included then in the Senate position, as well as that the governor shall not make criminal activity that's otherwise not criminal. That was from the House position as well. And I think that's all that come to mind right now, but it's a pretty good blend of, again, working on some things in the Senate position as well to clean those up and tighten up what the Secretary of KDHE cannot do, what the local health officers cannot do, and keep those positions in the House bill that weren't present or addressed in, or excuse me, keep those from the Senate bill that weren't addressed in the House bill. So while we have the revisers here and our committee here, other questions for the reviser?
I just wanted to make sure, it certainly may have others because there's some voluminous information here, but at the moment I don't.
For sure. So how about then we will reconvene, give you time to look at the balloons. Again, for those of you who have followed online and able to visually see the document, the balloons are very clearly identifying what's been added to the Senate bill, and the Senate bill has been out there for public review for almost a week, I think, when it had passed the Senate. So with that, then, we are going to reconvene and have the conference committee meet at noon. I apologize, it's over the lunch hour. If we can do noon, let's stand at ease for a moment to make sure we can do that, just a moment, and make sure we have the room available for noon as well. We'll stand at ease.
Madam Chairman, just from our side, I mean, I certainly want to keep this process moving forward, and I think, you know, we do need some time to dig through this to see what other questions we have. So I think it is important we get back together with that chance to ask questions. I would just say that I've been trying, as I shared yesterday, the key not only is us coming to an agreement, but we need 84 and 27 or 63 and 21, and so I've been trying to find those groups that I need to visit with to see what they think about this, and they're all in committee now, and lunch is about the only time they have available today to meet. Not saying that, I just hope we don't take up the entire lunch period. If not, it's going to delay this even further because I won't have a chance to meet with them till this evening.
Sure, and I don't want to, you know, I want us to have that opportunity. So we have 130 committees on the Senate side. I think you guys have something similar. And so can we do 12:30? Does that give everybody kind of some time to get with who they need to? And over here on the Senate side, it does.
Again, we will try our hardest. We have session at 11, obviously not much above the line, but leadership will be busy before and after that, so.
Right, and you're right, yeah, with session at 11, then all the 125 will be together and can
No,
find the groups, or
we don't come together every day like you all do, so.
we don't come together every day either.
Yeah,
But,
so we're not coming together at all this week, so the challenge
okay,
will
you're
be.
pro forma, is that what you're saying?
Yeah.
Okay, got it. Okay, well, does 12:30 to about 1:15 work?
Yeah, I mean, we
And we'll see where we are,
see
and
where we are, and maybe we can have more questions by then, and we can keep moving forward.
right, and I would anticipate also then probably meeting, because it sounds like we'll still have some questions after that, meeting again then at 4:30 like we did yesterday. So,
Except I have Judiciary at 3:30, and we have a number of conferees,
we
so
make it 5 o'clock?
I will do my best. You know how House Judiciary goes. and
Yes, it's busy, it's busy.
We've got an issue today that has been around for a couple of years, and we finally decided to give it a hearing, and it's got a list of conferees, so.
Sure, well, we'll wait till you're concluded, and we
Awesome.
will kind of tentatively set it for 5 o'clock, 5:15, and so when you guys are ready to roll then. So thank you all for